affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And I just need to make sure that you're speaking loudly enough into that microphone so that we can hear you, okay?
Okay. Is that better?
Yes. Okay. Ma'am, could you state and spell your name for the record, please?
Yes, it's Ashley Hall, Ashley Hall.
And where do you live, ma'am?
In Dicula.
I'm going to ask you about your relationship with the deceased in this case, Tara Baker. How did you meet Tara?
We were in the same sorority at Georgia College in Milledgeville, and then we ended up living together in the sorority house for a couple years. We both came to Georgia and ended up living together here as well.
Can you describe, in general terms, your friendship with Tara?
We were extremely close. Pretty much once we met, that was kind of came a little bit inseparable. And then when we both came here for I was doing my graduate studies and she was in law school, we were living together. Of course, you just didn't have as much time together, but we were still very close.
What kind of friend was she?
Wonderful friend, sweet person, always nice to everybody, always up for anything, very Southern Belle, very someone that was very into her family. Like, I felt like her siblings were my siblings by the time I knew everything about them, all about her mother, how wonderful she was. She knew my family pretty much about the same. Very black and white. She knew right and wrong. There was no gray with Tara. Like, it was, this is what you're supposed to do. This is how you treat people. Fantastic person overall. And I know people say that about a lot of people, but she really was just pure of heart, just a great person.
I want to take you back to August of 2000.
Okay.
And did you and Tara and Valerie Lowe all move in together?
Correct.
And how did the three of you come to decide to live as roommates?
Well, I met Valerie through the equestrian team at UGA. We both rode on the team. And then Tara came in '99 to work for the law firm. And unfortunately, I'd already signed a lease, so we couldn't live together that year. So we made a point. We made sure we were together the next year. And she got along with Valerie fine. And we were just very similar personality types, how we were raised, just both. Yeah, it turned out to be a great roommate situation. So,
where did y'all move into in August of 2000?
Fawn Drive.
In that time, starting in August of 2000, did all of you have boyfriends?
We did, yes. I was dating my now husband, Chris Hall. Valerie was with Jeff Hall, and then Tara was Chris Melton. We thought it was funny because we had two Chris's and two Halls in that whole set. So
let's talk a little bit about Tara and Chris.
Okay.
You recall how they met?
At Georgia College. Mutual friends. He actually was a cheerleader at Georgia College, and my brother was a cheerleader. And kind of just small school, you meet through that way. So
over the course of your friendship with Tara at Georgia College, up through and including moving into 160 Fawn Drive with her, did you have an opportunity to see her relationship with Chris?
Yes, we attended sorority functions all together. We went camping together. We went on trips together, just hung out together. So definitely immersed in their relationship.
In that, again, that fall semester, so starting in August of 2000, where was Chris living at that time?
He was living Jamestown Apartments, I believe it was, with Chase Guerin.
Is that here in Athens?
That's in Athens, yes, I'm sorry.
Do you remember where in Athens that is?
The Jamestown, right off of Millage, I believe.
Can you describe for the jury kind of what, at least inside y'all's house at 160 Fawn Drive, what that fall semester was like?
Well, I was starting my graduate studies. Tara was starting her law studies. Valerie was finishing her undergrad, and she was starting her grad studies the next semester, but it was busy. I mean, we were kind of passing each other, or we're just studying at all times. And then we had our boyfriends on weekends. We either would do something with the boyfriends, or we'd do stuff together too. But it was just that time of your life where you weren't getting any sleep and you were studying and, just living your life. So,
do you recall during that fall semester occasions where Tara would spend the night over at Chris's
Yes.
apartment? Do you also remember occasions when Chris would spend the night at 160 Fawn Drive?
not as much. It was mainly over there. So,
moving forward a little bit to the start of the spring semester, did you notice any change in Tara as it related to her relationship with her studies?
she was really buckled down. She was stressed with school. I mean, this UJ Law School, it was a tough department. I think Chris ended up moving back with his parents more, so they just couldn't see each other as much. And so mainly just really buckling down with school.
You mentioned Chris had moved back in with his parents. Do you know why?
He was helping his father. He was a plumber, and he just started working more full-time. So was starting his career and trying to go off on his own a little bit. He just was busy, and it just made more sense for him to work from there versus driving an hour to his work sites.
Where did Chris live, if you know?
Loganville?
Do you recall a time when Chris gave Tara a Christmas present that year?
Okay.
Do you remember that?
I know he gave her maybe a piece of furniture or something, or...
And without going into anything that Tara may have told you, did you get an impression as to her reaction to that gift? Does that question make sense?
Oh, anything he would give her, she was over the moon about. She just liked anyone to think of her. So usually if you just give her, you could have given her, I would draw a little picture sometimes when I was bored at work, and she would hang them on her wall, that's just, she just liked anyone to think of her. So anything he gave her would have been wonderful to her, so.
Turning to Thursday, January the 18th, were you at the house at 160 Fawn Drive that afternoon?
Yes.
Were you heading out of town that weekend?
I was. My class for Friday was canceled, so my boyfriend was going to Georgia State and ended up going to see him.
Do you recall being at home with Tara that afternoon?
Yes, we had a long conversation because with her birthday coming up, I actually had a horse show that weekend, so I couldn't go to her party. And so we were talking about what we were going to do to celebrate later for her birthday. And then we're just catching up on everything for the week, since it was rare for us just to have time to sit and talk.
So you mentioned a birthday. Do you remember what she was going to do?
I think go to a couple different places downtown Athens with her law friends and some people she used to work with.
Did she seem excited?
Oh, she was thrilled, yeah. I hated I was missing it. That was going to be, she was very excited.
Do you recall Tara talking to anyone on the phone that afternoon?
I think she and Chris talked on the phone, but they talked about every day.
If you know, was Chris planning on coming in town that weekend?
I don't remember if he could make the party, but I know he was coming in town and they were doing something for the birthday.
Objection, Your Honor. Hearsay.
All right, any response to the objection?
I didn't ask to elicit
I'm going to sustain the objection.
Did Tara appear excited about the weekend plans?
Yes, she was extremely excited about the weekend plans. And she was excited about seeing Chris.
Let's talk a little bit about Tara's morning routine. What do you recall about that?
She was pretty much a creature of habit. Shower in the morning, she'll go eat breakfast. She would always have 2 bags of cheese grits, because I like cheese grits too, and that was a bonding moment. Eat her grits and then go finish getting ready. She had really thick hair, so it took her forever to blow dry her hair. So usually she'll sit on the floor and flip her head over and blow dry her hair.
You went through that all really quick.
Sorry,
Really fast.
I'm sorry. Yeah.
And so I'm going to ask you to kind of break that down
Okay.
one at a time. How would Tara start her day?
Shower.
And what would she then do next?
She would go make her breakfast.
And where would she go to make the breakfast?
Well, she'll go to the kitchen to make the breakfast, and then she'll probably sit on the sofa and eat it.
And at that time, after eating her breakfast, is that when she would go back?
Go back in her room and finish getting ready, yes.
You indicated that part of that included blow drying her.
Yes, she had a lot of really thick hair, and so she would have to usually sit on the floor because she would get tired of standing up. And we've lived together since my freshman year, so it was kind of a joke, her sitting down on the floor, flipping her head over, doing her hair all the time. So,
What time would she start her day?
depending on the class, if she had an early class, she'd like a 9:30, probably 6:30, 7:30. She liked to get everything ready and then study for whatever classes she had that day.
So that would kind of start that routine?
Yes.
Depending on what time the first class was?
Yes.
In kind of the last months of her life, had you noticed anything significant about Tara's relationship with Chris?
I think she was frustrated they couldn't see each other as much. Of course, with her schedule and his schedule now working full time, like every girl, she wanted her boyfriend to give her a little bit more attention. But I think I had the exact same complaint about my boyfriend at the time. So it was normal conversations you have with your friend about their relationship. Nothing off or nothing that would have caused me to be alarmed in any way.
You feel like your relationship with Tara that you just described over the course of this afternoon, you would have recognized if there were...
Oh, yes. Yeah, like I said, Tara's very black and white. Like, we're not ones to share, like, maybe the little minute intimate, but we definitely knew what was going on in each other's lives. I mean, and if something was happening with Chris, since she knew I knew him and our relationship was what it was, she would have told me.
Ashley, or Ms. Hall, I'm sorry.
Yes, sir.
I believe I have a motion, Your Honor.
All right. I'm going to send the jury out. If you'll have a moment in the jury room and don't discuss the case. Thank you.
Just making sure.
Y'all may be seated. You have a motion, Mr. Cole?
Yes, ma'am, and I'd just like to put the basis on the record. As honorable court is aware, Mr. Faust has a restriction on his line of questioning that he could ask witnesses in regards to statements that Ms. Baker may have made to said witnesses. during the state's examination of Mrs. P.V. Hall, there's been intimations of, well, and I'll say what the exact statement was, that if something was going on, she would have told me. Well, we have evidence to the contrary, but as of right now, we can't confront that statement because of the Honorable Court's ruling. So before I move further with our motion, I would ask, would the Honorable Court reconsider its ruling in regards to our residual hearsay motion with the statements that we have that Ms. Baker shared through Ms. Ashley Peavy?
All right, thank you. Mr. Bolden, Mr. Yeoman, shall you care to respond to the motion?
It's asking the court to reconsider its ruling on our 607 before we move forward with any other motion. Our residual hearsay motion. 807, excuse me.
Your Honor, to the extent that the state has asked Ms. Hall to testify about anything that Tara may have said, I understood the court's admonition the first time and have intentionally stayed away from that. I don't think that I have failed to or I've elicited any testimony that would, violate the rule that requires notification. So I don't know exactly what Mr. Cruz is asking.
All right, thank you. So first of all, your request for a reconsideration of a prior ruling is not properly brought in this manner. That's not an objection. And I think you're misinterpreting my prior order. And so I think it would be imperative, Mr. Cruz, to go back and review what my orders were about. If you want to file a motion to reconsider, you certainly may do that, and I will consider whether it is timely and whether I should take it up. But I think your interpretation of the court's order is not accurate.
It is accurate, Your Honor. The order that you got.
I'm not going to argue with you, Mr. Cruz. I have made my ruling.
Well, sure. Well,
Do you have any other objection before I bring the jury back?
I
What
move
is your
for a
objection?
mistrial. And the grounds we're moving for a mistrial on, Ms. Peavy Hall was able to testify that Tara would tell me if there was anything going on with her and Chris Melton. We've submitted to the court and filed a residual hearsay notice to address those statements that were made. The Honorable Court advised us that we could not mention anything that Tara Baker told Ms. Peavy Hall in opening, and we cannot ask any questions related to that. Evidence has come into this case contrary to our 807 notice, residual hearsay notice, and we asked the Honorable Court to reconsider its restriction on the defense that is not on the state and allow us to ask questions in regards to that. The door has been open, Your Honor. We're just asking for fairness at this point.
Okay. Mr. Cruz, once again, you are misinterpreting this court's order. And
I am not, Your Honor.
Mr. Cruz, I'm not going to argue with you.
Yes, ma'am.
I'm just going to tell you what the court's position is. You are misinterpreting this court's order. It would be helpful for you to go back and look at the order and to review the law.
It's not written.
Mr. Cruz, I'm talking now.
Yes, ma'am.
It would be very helpful for you to go back and look at the court's order and to review the law that the court used in coming to that decision. This is not grounds for a mistrial. I'm going to deny your motion for a mistrial. If you want to file a motion to reconsider and it is filed properly, I will consider whether it is appropriate for the court to hear it at this point. We will, of course, do it outside the presence of the jury if the court decides to hear it. But until that motion is filed, I'm not going to consider a motion for reconsideration in this forum. But I do think it is imperative for you, Mr. Cruz, based on your arguments, to go back and look at the court's order and the law and to interpret it properly. And that is going to be my final answer. Would you please bring the jury back? Thank you.
Can we ask her about it? That's what the court hasn't ruled on, Your Honor.
Mr. Cruz, it would be imperative for you to begin your cross-examination. If there's an objection, I'll rule on it.
Yes, ma'am.
You all may be seated. Mr. Bolden?
Ms. Hall, talk a little bit about 160 itself, the house. Did y'all use the back door very often?
No, I think when we first moved, we might have looked out there, and that was about it. I mean, there's no reason to go in the backyard.
The window by the kitchen table, was that ever opened?
No, but I remember that it wasn't on the track correctly, so we could never really lock it. So I think we moved a chair back there, so thinking if someone walked in, we would hear it. But I think we did report that it was off track.
Did the three of you share keys with your boyfriend?
No.
Why not?
Like I said, we were very black and white on that. It was our house, and no boy should be there if we're not there with them. We were in law school, or grad school and law school, and just we're busy, and we don't need just a random person being there. And we were very respectful of each other's place.
How did you learn of Tara's death?
When we left, my boyfriend's in Atlanta, we first went to Winder, and then I went home, but my cell phone, like back there, we did not charge them, and mine was dead, because we just didn't use cell phones like that back then. And by the time I got home, my parents met me at the door and said there was a fire. My immediate thought was Tara left a candle burning. She loved candles, and but then we had to load up in the car and go to Athens, and I think just, you didn't believe it, because, and at the time we didn't know exactly what happened. We just knew there was a fire. So, of course, got to Athens and find out what happened, and I don't know. Some of it's kind of blocked out. I feel like your body shuts down when you get some type of that kind of trauma. But
Bear with me just.
no, you're fine. No, I'm here to answer whatever you need, both sides. But
Ms. Paul, thank you so much. I don't have any further questions
okay,
for you.
thank you.
Cross-examination, Mr. Cruz.
Ms. Hall, I think the most important thing, and I think everybody in this courtroom would agree, I am tremendously sorry for your loss.
Thank you.
I'm going to ask you some questions. Some of the questions may be a bit difficult. Some of the questions may be a bit uncomfortable, okay? But I want to let you know I am tremendously sorry for your loss. I would like to start with talking about Miss Baker's life and how you knew Miss Baker, okay?
Okay.
I think we'd agree that Miss Baker was in law school and she wanted to become a judge.
Eventually, yes. She wanted to do real estate law.
Is it fair to say that Miss Baker was known to have a keen sense of justice?
Yes,
Okay, she would listen, hear things out before she would make a decision on something.
I agree. Yes.
And would you agree, as you sit here today, you just simply want answers on what happened to Miss Baker?
Well, and we want someone prosecuted in
Correct.
crimes. Yes.
But the right person. Is that
The
correct?
right person, definitely.
Yes, ma'am. So you knew Miss Baker in undergrad, is that correct?
That's correct.
And you didn't just know her in undergrad, you two went to college together.
We did.
And you two were roommates in college as well, is that right?
Yes, correct.
And not only in undergrad, which was in Milledgeville, but you also were roommates here at 160 Fawn Drive.
Correct.
You would have no reason to disagree that if Miss Baker was here, she would say you were her best friend.
I would hope so. Yeah.
Ms. Hall, about a year and a half ago, do you recall being visited by law enforcement to discuss Miss Baker?
I do. Yes.
And as a part of that discussion, they asked you about Miss Baker's relationship with Chris Melton. Is that
Yes.
correct? And you didn't know Chris Melton just through Miss Baker. You knew Chris Melton because he went to undergrad with you
I
two as
did.
well.
Yes, I knew him before they ever dated.
And I believe Ms. Baker and Chris met at Georgia College.
They,
right?
yes.
Is it fair to describe Ms. Baker as, and if I say anything wrong, correct me, okay?
Oh, yeah.
Goal-driven and ambitious.
Very much.
And is it fair to say that you told law enforcement that Chris was very aloof and the fun guy to date in college, but not long-term?
If that's what it says, then that's what I said. But yes, they had a lot of fun together, and I feel like they just didn't have a lot of time for each other at that time. So it was a possibility that, like relationships do, sometimes they end, but that's not to me. That's up to her. So I have no idea if they would have broken up or stayed together, and we never will. So.
Yes, ma'am. That's fair. And you may have answered this. I just want to make sure it's clear for the court reporter. You described Chris as very aloof and the fun guy to date in college, but not long term.
Well, that was my opinion. That might not have been her opinion.
Yes, ma'am. And Tara and Chris were a match you never thought would happen.
Well, because she was very serious, and he was fun, and what they got together, and it worked. So that's all that mattered. There's a lot of people, I'm sure, that, in your past, that they didn't look like they would work, and they were fantastic together.
And when you and Ms. Baker were staying at the Deer Park apartment, she was dating Chris. Is that right?
Correct.
Okay. And Chris would come over to the apartment a lot.
He would come some, but they mainly went over to his.
Sure. And I want to make sure that I use the right term. Do you recall telling law enforcement that Chris came over to the apartment a lot?
I don't recall, but if I said it, then that's what I said, yes.
So,
No,
I
that's
just want to make sure I'm clear from the record. Do you not recall?
Yes,
Or-
okay, I recall I said that. I said it a lot. Like I said, I talked to many reporters and many people, so.
And Chris would sleep over as well. Is that correct?
Some, yes.
Based on your personal knowledge, you don't know whether Chris had been provided a key to Deer Park or not. Is that correct? Excuse me, the Deer Park house or not?
Personally, no, but she would have, one, told us if she gave him a key, and two, none of us would have ever given someone else a key that was not on the lease.
Sure. And thank you for that. And just to make sure it's clear for the record, to your personal knowledge, you don't know.
Of course, no one knows,
Yes, ma'am.
so.
As Tara's best friend and as her roommate, would it be fair to say that you had an opportunity to observe her relationship with Chris Melton?
Yes.
Is it fair to, well, let me rephrase that. When law enforcement met with you, you told law enforcement, I think once she started law school, I think they started dividing a little. Do you recall making that statement?
I'm sure I made the statement. The only thing I would mean by that statement is that he was starting his full-time job, plumbing, and she was trying to study. So they just didn't have the time together. And as I said before, that was just frustrating whenever you don't have the time with the person that you're with.
Yes, ma'am. And you also told law enforcement, and I quote, I mean, there were cracks already that, it was just he was wanting more time, and she's like, hey, I'm in law school. Do you recall making that statement to law enforcement?
I'm sure I did if you said I did, but she was in law school. She was busy.
Yes, ma'am.
That's a fact.
Would you agree that you told law enforcement when asked about Ms. Baker's relationship with Chris Melton before her death, you stated, I think just the normal, you could almost see it was the normal, you could almost see the ending of a relationship, if that makes sense.
Well, that was my opinion, but does not mean that's what was happening.
Sure, but that was based on your
No, it's just, as I said before, they just couldn't spend time together. And so it just looked like they're both busy. It did not mean one thing or the other. She was frustrated at the time. Again, does not mean that their relationship was ending. He was one of the nicest people ever and was always sweet to her, never showed any anger toward her.
And you told law enforcement about the frustration around them not seeing each other. Is that correct?
Yes, that's correct.
And is it true that you told law enforcement when you were asked, like they're starting to grow apart or he's getting on her nerves? Do you recall being asked that question?
I don't recall it, but if I said it, that's...
Would hearing...
But also, you have to remember, we were asked so many questions by so many times that it was getting on my nerves at that point. So sometimes I might have been a little abrupt.
Yes, ma'am. I know you mentioned that you don't recall it. Would hearing your interview refresh your recollection in regards to that particular question and what your answer may have been?
If it makes... Is there a reason for me to hear it?
Ma'am?
Is there a reason for me to hear it?
Sure, we could talk about it outside the presence of the jury, but at this time, the Honorable Court has only given me permission to ask questions.
Okay.
So would hearing your interview refresh your recollection into the question that was asked and your answer to that?
What exactly was the question, and maybe I can just answer it for you, how you need it answered?
Yes, ma'am. You were asked by Agent Bigham, like they're starting to grow apart or he's getting on her nerves. Your response was, I think it was just getting frustrated. And I think they both were because she had to study so much. Do you recall making that statement?
Well, I'm sure I've made it many times, but yes, she did have to study a lot. And when he had time, a lot of times she didn't, and when she had time, he had to work. It was what happens when people start their real lives. You have priorities, and you just don't have the time to spend together. But that doesn't mean that he hurt her or did anything to her.
Yes, ma'am. Is that a yes or a no to my question?
Do I remember making that? Yes, okay, I remember that statement.
Thank you. Do you remember telling Elizabeth Bingham, and I think that was, once she started dating Chris Milton, and I think that they were kind of on the outs before everything happened?
Well, they just didn't have, not on the outs, they just didn't have the time together.
Do you recall making that statement?
I'm sure I made the statement. I'm just saying that they did not spend as much time together as they had previously.
Yes, ma'am. But you do recall making...
Yes, I recall making that statement.
Your Honor, may we approach?
Okay. One other time. We are almost done for today, but if you'll go into the jury room, please don't discuss the case. Thank you.
Didn't mean to do that.
Y'all may be seated. Thank you. All right, go ahead, Mr. Cruz. And I have your motions that we were talking about. In general, I have all three of them that are pending. So I'm pulling up the one related to this witness. Go ahead.
As the Honorable Court is aware, on January 20th, 2026, Mr. Faust filed a notice of intention to introduce residual hearsay testimony pursuant to OCGA Section 248-807 in regards to Ms. Ashley Peavy. In court's indulgence, Your Honor, my computer just froze on me. I have a hard copy, actually. And we ask that the Honorable Court admit 3 statements from Ms. Tara Baker that were made to Ms. Ashley Peavy. The first statement that we ask for admission of is Ms. Peavy stated in her interview with law enforcement that Ms. Baker confided in her that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating. She didn't feel appreciated. The second statement from Mrs. Peavy Hall, please forgive me. Ms. Baker expressed frustration to Mrs. Peavy Hall, advising that Chris Melton wanted more time with her, but Ms. Baker was unable to give it. The third statement that we asked that the Honorable Court admit through Mrs. Ashley Peavy Hall is that Ms. Baker, the third statement, we asked the court not to consider that statement. We're asking about the first two. And the reason we bring this motion up, Your Honor, is because during direct examination, the state elicited testimony from Mrs. Peavy Hall where she stated that if there was something, and I'm paraphrasing, but if there was an issue in the relationship, Tara would have said something to her about it. I believe it was 2 other times because the state didn't exactly ask these questions. It was the answers that was given back to them. There were 2 prior occasions I just didn't say anything to, but once we hit the third occasion, I asked the Honorable Court, could it consider or consider making a ruling on our motion or reconsider its ruling on our motion.
I didn't make a ruling on this motion. It's pending.
Well, the pending ruling was not to make any statements in opening about it. It was restriction on defense counsel not to ask any questions related to our 807 motion.
We had a hearing. That's right.
Well, until Chris Melton testified. And after Chris Melton testified, the Honorable Court said it would reconsider our motion at that time, which I respect the Honorable Court. I respect the Honorable Court's order. But once testimony has come in from the witness that we have a residual hearsay motion pending on that's contrary to what we know the evidence would show, we're saying in essence that this has now become competent and relevant evidence that we could use to impeach the prior statement given on direct of Mrs. Peavy Hall.
Steve, care to respond?
Yes, Your Honor, and I'll just cite, there's basically in all of the notes on decisions here, there's a very good first sentence to all of them. The residual exception to hearsay is to be used very rarely and only in exceptional circumstances. That holding is in Brooks v. State, 365, Georgia App 711. And frankly, Judge, I haven't had a chance to read all of these cases. These are just the notes on decisions. Thrift v. State, 310, Georgia 499. Miller v. State, 303, Georgia 1. Those are in order. I'm sorry, I should have done this to begin with. 2022 Court of Appeals case, a 2020 Georgia Supreme Court case, and a 2018 Georgia Supreme Court case. These are certainly not exceptional circumstances, Your Honor. What they are is a couple of statements cherry-picked about minor regular relationship complaints that parties would have in an effort by Mr. Cruz to cast a certain light on the relationship between Ms. Baker and Mr. Melton. This witness, and I would just state, the court heard the objection from defense counsel to statements similar to the statements he's attempting to admit. And it sustained that objection and directed the state to move away. Defense counsel is not seeking to admit the third notice statement. And if we look at the first two notice statements, I don't believe there's a way to interpret those as being necessary in creating some kind of exceptional circumstance. The witness has acknowledged that there were challenges in the relationship that were created by a lack of time, and has not denied. She may not be familiar with each statement that Mr. Cruz has read to her that are purportedly quotes from the interview that she had with the GBI in 2024, but she has acknowledged that they had her perception of things may have been that they were drifting away, but she didn't have the ability to get inside of Ms. Baker's head, and her overall view of their relationship was nothing that caused her concern. I failed to see, residual hearsay is an extraordinary exception. If we think about all of the exceptions to the hearsay rules, there are well over a dozen. And so when you're going into this catch-all category, especially in a circumstance where you are picking random statements that Ms. Peavy Hall has referenced in talking about talking to law enforcement, and the only one that's close in time to the crime, the defense is not seeking to admit anymore. I'm not sure that there's been a date provided as far as when these statements were allegedly made by Ms. Baker to Ms. Peavy Hall. So that in and of itself, I think it's a failure to show how they would be extraordinary. This would qualify as an extraordinary circumstance. We don't even know the temporal relationship to these statements. You go inside any serious long-term relationship or any marriage, and if we're going to pick out times where one party or the other made some kind of statement about being frustrated by the conduct of the other party, that certainly wouldn't be an extraordinary circumstance. And that's exactly what Mr. Cruz is describing here, Your Honor. So I don't think the court should let it in under 807. The only other cases that I've seen, Judge, and I can look back and find them again, but when we looked at it when the notice was filed, most of the statements that I saw had things to do with statements directly related to the crime, either made by the decedent or made by some witness who was unavailable, not through any kind of wrongdoing of the party who is trying to admit that residual exception. And so I'm unaware of any case where a criminal defendant who is on trial for the murder of the declarant has been allowed under the residual hearsay exception to admit statements from them. I don't think Mr. Cruz is citing any case. There may be one out there. I'm not saying that, and that's not even really the determinative factor for the court. But I have not seen any cases where it was admitted in any circumstance that would be anywhere close to this.
All right.
May I respond, Your Honor?
May.
In regards to the exceptional circumstance, Ms. Baker is not here to speak for herself. As the state has clearly said multiple times, my client is the individual charged with Ms. Baker's death. So I have the burden of not only getting justice for my client, but also Ms. Baker. We're presenting the evidence that the state had and did not use. The exceptional circumstance is the state had all this evidence of Chris Melton's guilt for 24 years and ignored him. Even today, when I've given them, I've given you your own evidence, they still continue with the prosecution of Mr. Faust. Our position, the court knows this, is that Chris Melton did this. We're presenting the evidence to establish that Chris Melton committed this crime, and a part of that evidence is Ms. Baker herself saying, hey, these are the issues, or these are my feelings about my relationship with Chris Melton.
Okay, thank you, Mr. Cruz. All right, so I'm going to move backwards from 3, 2, and 1. First of all, number 3 has been withdrawn by defense counsel, and I've noted that in the motion, and I will order it withdrawn, and that will not be allowed. Number two is, has already been testified to by this witness. And so I'm going to deny your motion on number two. This witness did articulate what you are seeking basically to introduce in number two of this motion. And because of that, your motion does not meet the standard for the court to grant you the ability to have any of those statements introduced under 807. With regard to number one, I think what is important for me to tell you is that the state's comments that your request, Ms. Tara Baker confided to Ms. Ashley Peavy that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating, she didn't feel appreciated, is very vague and general in nature. I will let you at this moment, in support of your motion, voir dire question this witness about that moment that you seek to introduce. It's outside the presence of the jury. The court cannot make any determination about your request because of the vagueness of that particular statement. I don't even know what the statement is that you're seeking to introduce. The way that you have written it in the motion, and you may have just done it to put the court and the state on notice, and that's fine, is a general sense of what you're insinuating.
Sure.
But I know you're asking to introduce a specific statement.
Yes, ma'am.
I'm going to ask you to, if you choose to,
Yes, ma'am.
question this witness outside the presence of the jury about what it is you want this court to admit, the specific statement, but it also needs to have the specific supporting testimony, the foundation that Mr. Yamamoto was referring to.
Yes, ma'am.
Because it is not proper under 807 for the court to admit statements that are not particularized, that are not associated with something very specific. Just sort of a general request is not appropriate under 807. And so in the context that perhaps you were just giving the court notice of what you wanted, I'll let you voir dire or question this witness if you choose to, and then I'll let you cross-examine, sort of, or redirect, or whatever you want to call it also, and I'll make a decision.
Sure. Thank you.
And that's with regard to number one in your motion.
Thank you, Your Honor. Mrs. Peavy Hall, Agent Bigham asked you, what was she telling you about their relationship? And she is Miss Baker. Do you recall that question?
Okay.
Do you recall that question?
Yes.
Okay. And your response was, make sure. Your response to her question of what was Miss Baker telling you was, some of it's just guy stuff of not being considerate. You know, the girl's doing so much and feel like the guy's not reciprocating. Is that correct?
Yes.
Okay, and that's what Ms. Baker told you. Is that correct?
Yes, correct.
No other questions in regards to number one, Your Honor.
All right. Mr. Yamamoto, do you want to ask any other questions?
I don't have any questions.
All right, thank you.
Judge.
All right, Mr. Cruz, you haven't laid the foundation. I mean, I don't know when these statements happened. I don't know what circumstances the conversation you're asking to introduce happened between the victim in this case and this witness. It's a general conversation. You haven't laid the foundation. I'm going to deny your motion.
Yes, ma'am.
You may bring the jury out. All right, you may begin.
Okay.
Continue.
Yes, ma'am. Thank you, Your Honor. Your opinion of Ms. Baker's relationship with Chris Melton was that Chris Melton was not treating Tara well leading up to the time of her death. Is that correct?
My opinion was she was frustrated, but that does not mean that he wasn't treating her well.
Do you recall telling law enforcement he liked to flirt with other girls and everything else too?
Well, not everything else too. That probably was a little bit extra, but he was very friendly, but so was Tara. They were both very happy, friendly people and talked to everybody.
My specific question is, did you tell law enforcement that he liked to flirt with other girls and everything else too?
Yes to your question.
And sometimes you would hear Ms. Baker express frustration about her relationship with Chris Melton. Is that correct?
Sorry, I'm going to object to hearsay, Your Honor.
All right, here to respond to the hearsay objection.
I do. I'm not asking for a statement. I'm just asking for the witness's perception based on information given to her.
All right, I'll allow it. Go ahead.
Is that correct?
It's correct. We usually talked about being frustrated with our boyfriends, yes.
Okay. And not only would you hear Ms. Baker talk about it, you told law enforcement that you witnessed it for yourself. Is that fair?
I'm sure I did.
Now, we've agreed, or I believe we've agreed, on a couple of things regarding your knowledge of Ms. Baker's and Chris Melton's relationship. But based on your friendship with Ms. Baker and you being Ms. Baker's best friend, and I think we all would agree, I think both sides are on the same page that you were the person that she considered her best friend. Is it fair to say that Ms. Baker was not the type of person to speak ill of Chris to others to avoid making him look bad?
To a point, yes, probably. But she would still, if something really bothered her, she would have said something.
And just to make sure I'm clear for the record, in regards to my question, and if you can, just yes or no, but you can always explain. Is it fair to say that you describe Ms. Baker as the type of person that would not speak ill of Chris to others to avoid making him look bad?
Yes. She would also do it for me too, probably. But
now, again, I want to go back to Ms. Baker as the person, because I think that's the most important thing, tied with the most important thing in this trial. You would agree that Ms. Baker was not a pushover.
no, she was not.
She was very assertive.
She was quite assertive.
But she would speak her mind. If something was wrong,
Well, yes, but yes, she was not pushy. She was not loud.
and even as best friends, you two would get into disagreements.
Of course.
So it is fair to say that she's assertive, not timid. Is that correct?
She had things she was timid in.
Okay. But just speaking her mind.
She would have to be very, either something upset her to where she had to speak her mind, but she wouldn't just say something to somebody to say it. Like, she was not one to insult somebody, even if though she had a different opinion.
That's fair. Do you recall law enforcement asking you about racial biases of Ms. Baker?
Yes.
Okay. And is it fair to say that you advised law enforcement that she did not have any racial biases?
I did.
But you did say if you did her wrong, she might not ever forgive you.
I did. Yes.
Were you aware of the incident the week before her death between her and Chris Melton?
This was 25 years ago. You have to do a little bit more than that. So
Sure. As you sit here today, are you aware of a disagreement Ms. Baker and Ms. Melton got into, Mr. Melton, the week before her death?
I know she was frustrated with him, but we did not discuss exact details.
Okay, just to make sure it's clear for the record. Are you aware?
I am not aware of the exact confrontation that they had.
Yes, ma'am. Now, with these lines of questioning, I'm going to ask you some very personal questions, but I am not going to mention the topics. I'm not going to dig too deep, okay? So I'm going to speak in general terms. Is that fair?
That's fair.
Okay. During your interview with police, and again, I won't mention the topics, but do you recall being asked some questions about your knowledge of Ms. Baker's innermost private life?
Yes.
Would you agree that you told law enforcement, or let me change that. Would you agree with the statement, people do things without telling people, it doesn't matter how close you are?
I agree with that.
You would also agree with the statement that there are certain things, if they occurred, Ms. Baker would not advertise to anybody.
That's
Can we approach?
You may.
Your Honor, I would ask if there's objection, the state just makes the objection, Your Honor.
Well, y'all been coming to the bench this entire time. So why don't y'all come up here and I'll make a determination of whether we do it here or I send the jury out. Yes, sir. Hold on. All right. I want to make a statement before we get into your motion, and we'll do that since the jury is gone. Right? We're gone? Okay. Should have first. I want to sort of go back for a moment with regard to the motion of residual hearsay that the defense filed and that we've kind of heard argument on today, even though it was pending. The motion with regard to this witness is denied. Number 3 that the defense asked for was withdrawn. I've already made my comment about number 2. The second prong of the motion. But with regard to number 1, the first prong of the motion, I did deny it, but I want to elaborate for the parties why I denied the motion. The law requires, and I'm making a finding the defense did not provide this, the law requires, of course, that there be a sufficient foundation laid to provide that exceptional guarantee of what the law mandates, exceptional guarantee of trustworthiness. There was no statement under a belief of impending death or any statement against interest, which the statute, of course, refers to. That really isn't what this statement was about, but that wasn't present here. I did make it clear to defense counsel that the court needed a foundation about timing, about context, and things of that nature in order to assess the appropriateness of the motion. That was not provided. And so those are the reasons that this court did not grant your motion that you filed with regard to this witness to introduce residual hearsay. I'm making a further finding that it did not violate 403. There was no showing that the testimony was relevant, as the witness in this particular motion did not deny the statement she made to law enforcement. And even if it was relevant, there was not a sufficient showing that the probative value was substantially outweighed by the danger of unfair prejudice. And that is my finding on that motion. All right, let's talk about your objection to Mr. Cruz's question. Go ahead, and then, Mr. Cruz, you may respond.
Well, and Your Honor, it is an objection to any questions, which was the line of questioning that Mr. Cruz seemed to be headed down, that could touch on acts or inferences to be made to the jury by his questions that would violate the court's previous order regarding 412. Mr. Cruz is asking questions about the most intimate details of Ms. Baker's life. He is asking Ms. P.B. Hall questions about there may have been things that Ms. Baker has done that she wouldn't tell anyone about. And the state's fear is that Mr. Cruz is going to continue down a line of questioning that would result in trying to, which is barred by 412, it's cross-examination, but direct examination, cross-examination, or any evidence of any kind is barred that may touch in any way on any type of past sexual conduct of the victim. And I believe that that is what this line of questioning is. So it is a motion in limine asking Mr. Cruz not to continue down that line of questioning, which is barred by 412.
All right, thank you. Mr. Cruz.
I truly don't know what to say, Your Honor. We have a right to cross-examination. The state clearly just...
I can hear him.
Sure.
You hear him?
I just told me I need to use this when I speak, but I truly don't know what to say. The state just stated that I guess they believe, not that I've done anything, but they believe my questioning is leading to 412, which led them to request a bench conference that I wasn't, that I wanted to continue my cross-examination. They could have made their objection on the record. This isn't an objection. This is the state saying, hey, Judge, please curtail his cross-examination. We just don't like where it's going. The court has made it very clear what I can't. I'll say this. The court has given me 2 examples of what is off limits with 4012, and I understand the statute as well. This is, again, in essence, the state just saying, Judge, we don't like this line of questioning. We don't like where it's going. It violates 412, so put a restriction on them. And he even just asked for it. He said, Judge, this is a motion of limine asking you to put a restriction on Mr. Faust regarding his line of questioning. Your Honor, I am exhausted. I used to love coming to court every single day. This was my childhood dream. I am starting to just, me and Mr. Faust, it's a war of attrition. We're just dragging through this case. We're just dragging through this case. I would ask, Your Honor, that you rely on the law, the 412 statute. I'll prepare a brief if you want me to. Our office will put it together regarding 412 and what the cases say about Rule 412. I would ask that you deny the state's motion, and if we put anything in place, that the state, if they have a valid objection, make an objection. If I violate the court's order, the court can hold me in contempt if I violate the court's order. I understand what the court's order is. The only thing we're trying to do, Your Honor, I'm trying to get justice for my client. I'm trying to get the truth for the family. We're just trying to litigate a case. I would just ask that the Honorable Court allows us to litigate this case pursuant to the rules of evidence and not the preferences of Mr. Yalamachili and the state.
Thank you, Mr. Bruce. So I want to ask if I can get an understanding of your line of questioning that you're asking to be admissible. Where were you going with those questions?
Your Honor, these are exact quotations of statements that she's made made to law enforcement. If the Honorable Court wants to know exactly where I'm going with that, I could do it outside the presence of I would ask to do it outside the presence of the witness.
All right, fair enough. Could I have you, well, actually, I don't think we need this witness now at all, unless there is something else we need to discuss with this witness.
That's correct, Judge.
All right. I'm going to ask that you return tomorrow per your subpoena, and you're free to go for now. Thank you. Go ahead, sir.
Yes, ma'am. The sole purpose of this line of questioning, Your Honor, is summed up in one sentence that we were going to use in closing, that Tara did not share intimate details of her private life. So what the state just did, stopping the cross-examination, was to prevent us from saying one sentence in closing. And that sole sentence, Tara does not share intimate details of her private life. I would ask that a restriction is put on the state. They are more focused on convicting Mr. Faust than finding out the truth and letting the evidence stay where it needs to stay. The evidence speaks for itself. Mr. Yalamachili doesn't have to speak for the evidence. I don't have to speak for the evidence. The witnesses can come in and present the evidence. I have a double burden on me now, right? I have to make sure this family finds out what happened, what evidence we have, but I also got to defend Mr. Faust, knowing that anytime he gets any traction, the state jumps up. Judge, stop him from doing this. Judge, hold him in contempt. Judge, we object to this. Your Honor, I just ask that we have opportunity to present this case. I respect the court, but it is hard to drag on every day knowing Mr. Yalamachili at any given time, just any given time, is going to jump up and make some type of objection, run up to the judge and say, Judge, he's doing this, stop him. We just want to present our case.
Okay. All right. So first of all, I think that both counsel have jumped up and, in your words, made objections throughout the case from beginning to end, and that is fine. That is what lawyers do. I don't think one side is doing it more than the other. And so I think that the record needs to be accurately reflected. So let me say that first. The second thing I do want to ask you, Mr. Cruz,
Yes,
is, are you asking permission? I mean, I realize that you didn't intend to ask permission, but I'm asking you now, sort of in the context of what we're talking about. Are you asking permission to ask that witness, is it true that Ms. Baker did not share all the intimate details of her life with you? Is that what you're asking?
What I'm asking is the Honorable Court to protect Mr. Faust's right to cross-examination.
Mr. Cruz, I certainly will do that, but we are really getting into the weeds with regard to this motion. It's very necessary. So that's my question, is that are you asking to be able to ask that question?
Let me ask this question. Is the Honorable Court saying that I need permission to ask that question?
Well, not necessarily, Mr. Cruz, but I'm trying to get at the heart of this matter. So this is kind of where we are.
Sure.
And we have been talking about Rule 412 for days. We talked about it a lot before this trial started, and we talked about it a lot this week. And I guess I'm just going to repeat what I said the other day, but I'm just going to repeat it. When the state filed their motion and the court heard arguments from both sides about 412, the defense noticed in court orally to the state that the only person that they would seek to introduce evidence with regard to 412 was Chris Melton.
That motion is in writing, Your Honor. We filed a written motion in regards to that, and we had a hearing and the Honorable Court granted it.
Okay. The motion was initially by Mr. Yellman-Chili. I'm talking about the verbal notice that you gave to the state during our hearing that that's what you would do. Okay. That's what happened. And we discussed this in court, and you made it very clear that that was the only person you were giving the state notice for. And based on the defense's not giving notice to the state about any other persons for us to be able to talk about whether that would be appropriate, that's kind of where we are. And so every other discussion about any other exception to 412 was prohibited. That's the prohibition, right? And I've said many times that if you, for whatever reason, felt that you needed to change your response, you could file a motion, and I would determine whether it was timely and we would hear it. And so that's where we are. The Chris Melton questions are not off the table. You gave notice to the state that you would seek to introduce evidence about the relationship of Tara Baker and Chris Melton. I mean, I think that's that's not open for debate. And so I think and Mr. Yellman-Chili, I don't want to put words in your mouth either, but my sense of your objection is that you are, once again, concerned that the defense is trying to elicit testimony, either directly or by insinuation, that other persons' behavior or relationship with Ms. Baker could be introduced in violation of 412. Is that a fair statement, or is it something different?
Yes, Judge, that's correct. The way the line of questioning was progressing, it started with a question about Ms. Baker not having a racial bias against any persons. It then immediately went into the realm of intimate details about her life that she wouldn't share with anyone. And so in conjunction of those things, it seemed very clearly to me that there was at least a risk that Mr. Cruz was going down a line of questioning. Now, I think we excused the witness so that Mr. Cruz could proffer to the court what his actual questions would be, which he did not do. He just referenced that the questions were in support of something he was going to argue in closing, which I'm not asking him to give us his closing argument. It's just the direction in that these questions are going. If they're relevant for some other purpose, or I misinterpreted the direction they're going in, then I apologize, Judge, but the state is acting out of abundance of caution. Violations of 412 are serious things, and you can't necessarily unring that bell. It happened twice in opening statements. So when we see a direction that Mr. Cruz seems to be heading in, I'd like the court take some action, either to again instruct Mr. Cruz that that is not relevant or admissible. I guess relevant wouldn't be the right terminology. It's not admissible or proper to inquire into due to his failure to notice the state. And as he said before, there's no evidence to that fact. So, Your Honor, that's the basis of the state's motion in limine. And so I don't know what additional questions Mr. Cruz was about to ask, but it seemed like we were getting to the point where he was trying to skirt that line again.
Okay, and I'm going to ask you a question, Mr. Cruz, and I'll certainly let you respond. The state didn't object to the relevance of the question about whether Ms. Baker had a feeling about race relations or anything of that nature, but I understand, based on the context that you're arguing, that you're referring to the relevance of those questions. So I guess, Mr. Cruz, that's where the court needs to hear, I guess in terms of a proffer would probably be best. What is the reason you're asking those questions?
Sure. And I don't mind giving it to the Honorable Court. I would just ask moving forward that the Honorable Court puts a restriction on the state, because I think this is the second or third time I've had to proffer our strategy to the state. I've not once asked this court to intervene to tell me where the state was going with their examination. I do believe it violates Mr. Faust's rights.
Let me just answer that real quickly.
Well, Your Honor, it
I'm
violates
let you
Mr.
talk,
Faust's
Mr.
rights to a fair trial.
Okay, hold on, Mr. Cruz. I'm going to let you respond, but I want to respond to something because you've used this word many times. You keep saying that the court has put restrictions on the defense and not on the state. Mr. Cruz, the court doesn't do that. The court listens to motions and makes rulings according to law, and those rulings are the restrictions themselves. And so it is a tremendous mischaracterization of what the court has ruled on and the reasons why to simply say the court is putting restrictions on the defendant. That is not appropriate. And I know that you know that. The court has heard motions. It has made rulings which you may very well disagree with, and I certainly understand that. But the court doesn't put restrictions sort of unilaterally on any party. It listens to motions. It looks up the law and makes rulings to the best of its ability based on those motions and the law. And so the restrictions you're referring to are based on those decisions. So I want it to be clear that this court is not putting restrictions on one party over the other, but it is simply the result of rulings that were made according to law. Now,
Judge, may I?
You may.
Denied motions that they've consented to because, in my opinion, they benefited Mr. Faust. We had a motion to suppress that you denied that the state consented to.
Mr. Cruz, I want to stop you there because you know very well that is completely disingenuous.
That is
Mr.
not
Cruz, I'm talking right now.
Yes, ma'am.
You know very well that what you are referring to is actually completely inaccurate. There was, and we are not going to relitigate motions, but I certainly want to make sure you understand that I know that that is not that is a tremendous mischaracterization of what happened. We had a hearing on a motion to suppress that you filed, and the state consented with the defense about one of the allegations. And this court said, that's fine. Provide the court with a stipulation and I'll sign it. I don't have any problem with both parties consenting about part of your motion. That stipulation has not been entered, and I believe that was because the defense has not provided the stipulation to the state. You can respond about whose fault that is, but I don't have the stipulation. But I also denied the rest of the motion to suppress based on the evidence and based on the law. But the one moment you're referring to, Mr. Cruz, and you know this, where the state and the defense consented about your allegation in the motion to suppress, and I supported that. You know that to be the truth.
I do not.
It is not appropriate for you to continue making a statement that is false.
That's the truth, Your Honor. The same day we received the order denying it, we didn't have opportunity to put a stipulation in because after our motions hearing, either that day or the next day, the Honorable Court issued an order denying all our grounds for the motions.
Mr. Cruz, that's not accurate. I would have accepted any stipulation because I ordered you to provide it to the court. And if both parties still want to give it to the court, it'll be part of the record. It is on the record. It is on the record that will be transcribed. And so that stipulation has been entered and approved by the court, even though it's not in writing. But it has been authorized. Let's move on. And if you would proffer for the
Yes,
court
ma'am.
what it is you are seeking to admit, I can make a decision as to whether it is relevant and whether it is admissible. I just don't
Yes,
know what you're trying to do.
The state had the opportunity to present the testimony of Miss Lauren Sherling. Ms. Sherling came in and testified, and the state elicited this testimony that there were no issues in the relationship with Chris and Tara, based on, and I think the state explicitly asked this question, based on what Tara told you, what was her, and I'm paraphrasing, but pretty much what was the nature of her relationship with Chris Melton and, what was the nature of the relationship between Chris Melton, please forgive me, Your Honor, Chris Melton and Tara Baker. And her testimony was that it was good. The line of questioning that we are going down to separate Mrs. Ashley P.V. Hall, who is actually her best friend, not Miss Laura Sherling. Mr. Sherling, I think, knew her for 6 months, is that Ms. Baker, one, and we elicited this when she was testifying, one, she wouldn't talk bad about Chris to other people because she didn't want to make Chris Melton look bad. So Ms. Sherling, who was a 6-month friend, I tell you, I hate to even have to share this because this is what we talk about in closing, but I'm following the Honorable Court's order. Ms. Sherling, who was a 6-month friend versus someone who went to undergraduate with this young lady and who says, hey, these aren't things she would tell people, is exactly what we're using to build our defense in Mr. Faust. It is extremely important if the state wants to bring a witness in here and have them testify to something, that we're able to rebut that. Our position is this, Your Honor. We have the same evidence. I have introduced nothing new. So when the state calls me disingenuous, and I took that I couldn't believe it. When the state calls me disingenuous, but they have all this evidence that they're excluding, they don't want the family to see, they don't want the jury to see, and we have to present it, and then when we are presented, they come up to the judge and say, Judge, he should preview where he's going. I believe it's 412, but I don't know if it's 412. That is an issue, Judge. It is hamstringing Mr. Faust's defense.
Okay.
The only thing we ask is the court says, hey, state, do your job. If you want to prosecute Mr. Faust, present the evidence. Don't come at the attorney. I've had personal attack after personal attack from Mr. Yalomachili, and I have never gone out of my way to say anything ill about Mr. Yalomachili. Even when I see him in the hallway, I speak to him. I'm polite, but I know when we come in court, at some point, Mr. Yalomachili is going to get up and accuse me of something or either ask for me to be held in contempt. Your Honor, we're just asking to present the case. That is the basis of our questions. We just want a sole sentence and a sole argument that says that Tara Baker does not share the intimate details of her private life. So when the state does their closing and they say, well, you heard from Ms. Sherling that the relationship was great, we would have put testimony into the record that, hold on, don't listen to that. This is her best friend, and her best friend is saying Tara Baker was a private person. That's where we're going with our line of questioning, Your Honor. But I would ask in the future that the Honorable Court, if they have a lawful objection, even if they want to make an unlawful objection, they just do it in their place. If it's an issue that Honorable Court feels, if I'm doing something wrong, Your Honor, you are the power in this courtroom. You are the ultimate power in this courtroom. If I'm doing something wrong, Mr. Yalomachili isn't the one that has to get up and say it. You could tell me. You could say, Mr. Cruz, that is inappropriate. Mr. Cruz, you can't have that line of questioning. When the court gets involved for Mr. Yalomachili, it's when he has a lawful, or even if he wants to, an unlawful objection. But an objection. That's all I'm asking, Your Honor. But that is the proffer in regards to the reason for that line of questioning.
Okay, okay, thank you. I still don't have my question answered. So I'm going to ask you some questions.
Please forgive me.
All right. Well, I mean, there's a lot going on. And so, but I need to be able to address the state's motion. All right. First of all, with regard to the objections for both parties, it is easier, of course, to handle objections right from your place. But both parties have asked to come up to the bench a lot. I'm okay with that, given the kinds of objections you all are making. I know that there are certainly things you don't want the jury to hear, and I am not there are some rulings I want to make that I do not want the jury to hear all of the things that I say, because I think that would not be helpful to either party. And so if you want to continue asking to approach the bench, I'll entertain it. If you don't want to do that, that's fine. I mean, I'm going to leave that up to the attorneys. What I don't understand, Mr. Cruz, is this. The issue with Mr. Melton is different than I think Mr. Yalamanchili's motion. Mr. Yalamanchili's motion alerted the court again to a line of questioning that would seek to admit testimony about other people. Quite frankly, that's it, other people. And that is my question for you, Mr. Cruz, is the line of questioning that you said about whatever the statement was, and I didn't write it down, about race relations and about
I can answer the question. I know where you're
that's what I need to know. Is,
Sure.
And I think, that is what we're talking about.
That is fair.
When we're talking about 412.
That is fair.
Go ahead.
So a part of my examination of Miss Ashley Peavy Hall, something that I found that it was very important to do was to show how great of a person Miss Baker was. I've read this entire discovery file. Me personally, and I'm not a witness in this case, she was, from what people said, she was a really kind and amazing person. She was assertive. She was straightforward. She didn't have any biases. I am just, and I said it to the witness, I said it to the honorable court, let's talk about Miss Baker's life. I said it in opening. That's all I'm doing, Your Honor. But they've taken me talking about Miss Baker to say, well, Judge, he's going down this line. Anything I've said.
Well, I need you to answer my question.
Sure.
Mr. Cruz.
It's about who Miss Baker is as a person. The state has not tried to present Miss Baker as a person during this entire trial. They focused on trying to make him into a person guilty of her murder. My job is twofold, as I mentioned, Your Honor. I want the family to know the truth of what happened to their daughter, and I also have to defend this gentleman here. And if the jury believes he's not guilty, let him go home.
Okay, Mr. Cruz, I understand all that. I do. You've said that many times. I understand that it's your position. But you haven't answered my question. And this is what I need to know. Very specifically, Mr. Yalamanchili's motion, his objection, which he has made many times since we started, were objections to either statements about other people or statements that appear to lead to that line of questioning. That's my question for you, Mr. Cruz, is
That's very vague because they've taken a question about Miss Baker and turned it to a 412 argument, Your Honor. So maybe I'm not understanding the Honorable Court's question. I thought the Honorable Court was asking me to explain the purpose of the question about her racial.
I am.
Correct.
I'm not getting the answer. That's why I'm keeping
The answer to that question is through Miss Ashley Peavy Hall, her best friend. Our goal, one of our goals in this examination, is to show the jury who Miss Baker was. We talked about her being a law student. We talked about her being ambitious. We're giving them a profile. The state hasn't given anybody a profile about Miss Baker. I have to, but I'm doing it. This is a 24-year-old, 25-year-old cold case. I don't think Mr. Faust is just a victim. I don't think Miss Baker is just a victim. I truly feel the family is a victim too. So what I'm doing is at least, okay, jury, this is what you need to know about Miss Baker. We're going to have a time where they get to know about Mr. Faust, and then we're going to get into the prosecution. We're getting into every aspect of this case. So in regards to your particular question of why we asked about race is to give the jury a piece of a profile to Miss Baker. We asked about her education. We asked about her ambition. We asked if she was goal-driven. We asked about her personality. Was she assertive? We even asked about their relationship. Did you two butt heads? I don't understand, and maybe it's just me, how we get from he's talking about Miss Baker to he's talking about her character under the under Rule 412. I'm flabbergasted. My mind is blown. I don't even know how we get to this point based on the questions that I'm asking.
Mr. Cruz, let me ask you this. Why is your question about how Miss Baker felt about race relations relevant?
Because Miss Ashley Peavy told the detective that everything that she told the detective about Miss Baker, we're introducing. That honorable court.
What are you asserting she told the detective about that?
That she wasn't, she had no racial biases.
Okay.
Is that, and maybe I'm wrong, Your Honor, is that sexual? Am I being inappropriate by my line of questioning? And I think that's what Mr. Yalamanchili is bringing up to the court.
Well, okay. Now I understand what you're saying. I'm going to let the state respond, and then I'm going to respond. Mr. Yalamanchili, do you want to say anything else now that we've kind of gone through this moment and there's been a specific comment about a statement that was made in an interview?
Right. Well, it's not the question about race relations and the fact that Ms. Baker was not racist. I mean, that's not the issue. The issue is immediately thereafter.
Mr. Cruz, I'll let you respond. You got to let Mr. Yalamanchili speak too. You can't have two people talking.
Immediately thereafter, Mr. Cruz went down a line of questioning with no segue, no change in topic or anything like that, saying, you know, would Ms. Baker share the most intimate details of her life? And then aren't there things that Ms. Baker would never tell anyone, even if she did them? Was essentially the question.
Okay.
I'm paraphrasing just a little bit.
Okay.
And Mr. Cruz is headed down that line of questioning, which seems to go down lines of questioning that try to toe the line around Rape Shield and create the impression that Ms. Baker may have engaged in some other types of relationships that Mr. Cruz would like to put in the jury's mind without following the appropriate procedures. And I mean, as the court says, you know, asking the parties to follow what the law requires is not handcuffing anyone. It's just applying the law to these proceedings. I would also note that from a relevance perspective, because someone told the police something doesn't make it relevant or admissible in court. So I would respond in that way to that.
Okay. You wanted to say something, Mr. Cruz?
If I may, just to, I guess, kind of summarize things. I hear where Mr. Yalamanchili is coming from. I believe that, first, he has not made an objection to anything that Mr. Cruz has actually said. I want to note that at first. Secondly, I will like to note that it seems, so any comments or questions that have been asked about her intimate life at this point, her intimate life can entail a number of things. It could potentially include sexual things, but it could also include things that are not particularly sexual. At this point, I do not believe that Mr. Cruz has asked any questions that have actually been objectionable. So any objection at this point, I do think would not be ripe. If Mr. Cruz does get to a question that is objectionable, I think that then Mr. Yalamanchili's objection would be appropriate. But at this point, I do not believe that Mr. Cruz has made an objectionable statement or asked an objectionable question. So I would respectfully ask the Honorable Court to deny his request. And Mr. Cruz, I think through this conversation, is reminded of the court's admonitions around 412. And I'm sure he will be mindful of that as he proceeds moving forward. But at this point, I do not believe that he has asked anything objectionable. And if he does, then the state can make the appropriate objection.
Thank you. Is it Hall or Hill?
Hill.
Thank you, Mr. Hill. All right, Mr. Cruz, anything else you'd like to tell the court?
I just don't know what to say, Your Honor. Our cross-examination was stopped just for Mr. Yalamanchili based on his belief that this was a 412 issue. Another thing I would say, Your Honor, is Mr. Faust doesn't feel protected in this courtroom. I don't feel protected in this courtroom. And I feel that the Honorable Court has been leaning extremely favorable to the state. I've been nothing but respectful to the Honorable Court. I've been nothing but respectful to Mr. Yalamanchili's case. Anytime I've approached the bench, it's been because there were sensitive issues that I did not want to address to the jury. I've never once approached the bench and say, hey, Judge, I think they're about to do this. Let me stop them and let me send the jury out. One thing I'd ask, Your Honor, is Mr. Faust is on trial. Constitutional protections apply to Mr. Faust. Mr. Faust has the right to effective assistance of counsel under the Sixth Amendment. He has the right to cross-examination under the Sixth Amendment. He has the right not only to effective assistance of counsel, but his choice of counsel. Your Honor, right now, we don't feel this trial is fair. I'll just say in my place, I do believe the Honorable Court is going to grant his non-objection, so I'm sure I won't be able to ask these questions, and I'll make do with whatever I'm allowed to do. But, Your Honor, I respect this Honorable Court. I would just ask, there's a gentleman here fighting for his life. He is fighting for his life. He has no hope. You're his only hope. We're just asking that we have opportunity to present our case, and if Mr. Yalomachili has an objection that he needs to make, just make the objection. And if the honorable court finds that it's lawful, stop me, and I'll stop. That's all I ask, Your Honor.
All right, thank you, Mr. Cruz. All right, so with regard to the objection, I think what we're going to do is we're going to put the witness back on the stand. And Mr. Cruz, you may ask her the question that you proffered, which is something about, did she share everything with you about her personal life, right? The motion in limine that the state is asking the court to grant has already been granted. I have already granted that motion in limine, and I've talked about it several times. And so you just need to be aware, Mr. Cruz, that you cannot go forward after that question with any insinuations, for example, which I think is what the state is probably concerned about, insinuations about other persons. You can't do that. That would be a violation of the motion in limine that has already been ruled on in this case. It was ruled on again several days ago, but it was also ruled on when we had our 412 motion. So I'm not going to redo a motion in limine. It is already on the record. I will certainly hear any objections outside the presence of the jury. We've been doing that in the entire time. I'm not going to, order that you all argue your motions at the table. Things are getting heated. There are sensitive topics. We've made a habit of coming to the bench and sending the jury out, and I think we're just going to have to continue on that thread. But, Mr. Cruz, you can ask the question if whatever the question, however it was phrased, about whether Ms. Baker shared all of the intimate details of her life. That could be relevant. There has been testimony elicited that Ms. Baker was a private person. There has been testimony elicited that she was best friends with this witness or close friends with this witness. You can ask that question. But you need to understand, you can't use that question to then get into any testimony about other persons. Chris Melton is the one that you noticed the state was fair game, for lack of a better way of saying it. And the state is on notice about that, but no one else. And that's what I was referring to when I said there's been no 412 motion filed. If the defense finds it necessary for them to attempt to go down a line of questioning where other persons were, questions about other persons needed to be had, you have to file the right motion. And I will schedule it. And we will have a discussion. I mean, it won't be timely, but I'll schedule it. I've told you that. But am I clear about that? I mean, the motion that you're asking me to grant Mr. Yalomachili has already been granted prior to today. And so I'm not going to re-grant it. Yes, sir.
I'm clear. I think you asked me if I was clear. Yes, ma'am.
Okay. Any other questions?
No, ma'am.
All right. We're going to adjourn, and I will see you all tomorrow morning at 9 o'clock. Thank you.